we were faced with this situation where it's clear that, you know, the regulations were going to drive most of the products off of the market. And we're starting to see that come alive. And also with natural health practitioners losing treatment options. Then Bill C-51 came along. And, you know, the NHPPA, all these other groups, were spending all this enormous time, all these resources, we're mobilizing people to try and stop this bill. I mean, that year we probably lost over 10,000 natural health products. If that bill had passed, and it still may come back in another form, you know, in the very near future, and could pass, our access to treatment options are being whittled away in. So we started thinking, well, we need to come up with a solution. What the Charter of Health Freedom does is actually try to address a disconnect between what Health Canada is doing and what the courts are doing. Because actually, if you start reading court decisions about our right to choose how we're going to treat ourselves when we have a health crisis, the courts always say, no, listen, if you need a treatment, it doesn't matter what it is, for a health condition, then it doesn't matter if it's illegal, the state has to let you have it. The courts say, no, we have absolute sovereignty over our own bodies. In fact, Section 7 of our Charter, which protects our right to life, liberty, and security of the person, courts have interpreted that to say that includes the right to make fundamental health decisions. That includes the right to have treatments that you rely on for your health, regardless of whether or not Health Canada has issued a license. So we have the courts saying we have these health freedoms that are wonderful, and we have the government ignoring them, taking our freedom to choose away. And so all the Charter does is it actually takes, well, we reiterate Section 7 of the Charter, and it lists the rights that the courts say that we already have. And, you know, how can the government object with that? How can anyone object with that? No, we don't agree with these rights in the Charter. Well, like, hello, the courts say we already have them. So it sets those out, and it compels the government, Health Canada and every other government bureaucracy, to adhere, to honor the rights that the courts say that we have, and it creates that wonderful health freedom ombudsman to be a watchdog and make sure that the government is following the law. It's already the law. The courts tell us it's our law, our constitutional right, our common law right. Now, the Charter of Health Freedom also creates a different ministry, a ministry of wellness, to basically manage the natural health community, not just natural health products, but low-risk medical devices and other treatment modalities that are low risk. And the reason why we do this, why we decided to put that in the Charter, is, you know, we've got this pattern of behavior with Health Canada, which is very negative towards the industry. And one of the reasons why that could be is that Health Canada regulates some very dangerous things. So, for example, when we talk about the chemical pharmaceutical drugs, there is a really high risk profile, and it's appropriate to assume that those things are dangerous. And in fact, I think we could credibly argue that they need to be more restricted. But when you apply that mindset that's appropriate for them to have there onto natural health products, it's inappropriate. In fact, I say natural health products should be presumed to be safe. And some people in media go, oh, isn't that dangerous? Well, you know, we look south of the border, natural health products, they're called dietary supplements there. At law, they're presumed safe. And the FDA can only take them off the market if there's evidence of harm. Now, I travel to the United States frequently. Maybe I need new glasses or something. I just have not seen Americans laying dead on the streets. I go in their malls and they're walking, and they just seem, you know, really as healthy as we are. I don't think that's created a danger there. And we know because of the low risk profile that there isn't a danger. So, but some people really resist that suggestion. Ironically, some in the industry and definitely the media, you know, when I suggest, no, they should be presumed safe. Now, the Charter of Health Freedom deems them safe unless there's evidence of harm. But it also forces the government, if you're going to take something like a natural health product off the market saying it's risky, you have to do a full risk analysis and go, well, what's the risk of removing it from the market? Because if the risk of removing it from the market is greater than the risk of leaving it on the market, then you can't remove it from the market. Because isn't this about safety? Like, one thing I find ironic is the government of Canada, in the name of safety, never takes into account the risk of removing a product from the market. But you and I, Canadian citizens, we're not the government, we actually at law have to take into account the risk of removing products from the market. And let me explain. Because I get a lot of calls from manufacturers like, Health Canada's just told me to recall my product because my label's not compliant type thing. Like, it can just be minor things. And because whenever there's any problem, that's what Health Canada says, recall the product. They deem it safe, recall the product. And I have to ask the manufacturers, well, does anyone rely on your product for a serious health condition? And I ask that question because if somebody relies on your product for a serious health condition and you remove it from the market and they're harmed, or worse if they die, then you are committing criminal negligence, either causing bodily harm or death. And in fact, in the True Hope case, as I told you, the judge told True Hope in his oral decision that if they had taken the product off the market, they would have been committing criminal negligence causing death. The penalty for that is life imprisonment. So as a lawyer, I have to advise people, well, what are their rights and obligations? And I find it really interesting that us, the non-government, we have to take into account the risk of removing something off the market because we don't want to be criminally negligent, but the government doesn't have to. And I say that's backwards. Because isn't the government there to protect us? So the Charter of Health Freedom requires them to take into account the risk of removing a product. All it does is require a balancing of risk. And I say that's reasonable. So another nice thing about the Charter is really the energy behind it. Because we've been reacting as an industry, we react against the regulations, we react against Bill C-51, we react against Bill C-52, we react against Bill C-6, it's all negative. And nobody's ever come up with a workable solution to try and solve the problems. And what I like about the Charter is it's a positive solution. It's actually a way to fix this. Now we still need to then, if we can get the Charter passed, we still need to be vigilant in protecting our freedom.